Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, loyal, ambivalent, and even adverse listeners. How you doing? As I've mentioned before, I'm honored to be on the Immigration Advisory Commission for the American Bar Association's Commission on Immigration. All of us immigration attorneys have thoughts about the results of the election, of course. Here's some from Commission on Immigration Chair, Michelle Jacobson, taken from a longer call to action that she issued earlier this week. As the dust settles from our most recent election, immigration advocates are feeling grim about the prospects for immigration reform in the United States. Hearing news about mass deportation plans and an expected end to many of the humanitarian programs, immigrants with and without legal status feel unease about their ability to remain in the United States. Elections serve as an important reminder of the values we cherish most in civil society: democracy and civic engagement, which must remain strong regardless of our feelings about the outcome. Now is the time to channel our energy into a renewed commitment for change. Every effort we make, no matter how small, contributes to the larger goal of creating a fair and more just immigration system. Pro bono advocacy is the backbone of our fight for justice. By offering our skills and expertise, we provide essential support to those who might otherwise be left without an avenue for legal status. This work not only changes the lives, but also strengthens our communities and upholds the principles of due process and justice. Michelle continues, "Let us draw inspiration from the countless stories of impact that have emerged from our community. From reuniting families to securing legal pathways for those immigrants arriving within our borders, our collective efforts have brought hope and safety to many. These stories remind us of the tangible difference we can make and fuel our determination to continue the fight." Well said. Links to the ABA Commission on Immigration in the show notes. And it's not just words, heck. Look no further than this Ninth Circuit decision that I'm about to discuss to see the tangible difference that we can all make. 4 more cases as well for your listening pleasure this week. Starting off with Aleman Belloso v. Garland, published by the Ninth Circuit on November 13th, 2024. This case is about asylum, nexus, political opinion, and other things. Mr. Aleman is from El Salvador and, quote, was an influential lay minister in the ELIM, Christian Mission Church in his hometown of Lourdes Colón, La Libertad, end quote. He led youth groups, preached, and led quarterly meetings attended by 300 to 400 people. And while his, quote, influence in the community caught the attention of local members of the FMLN, El Salvador's primary left-wing political party, end quote, that controlled much of Salvadoran politics at the time of these events. In August 2015, representatives from the mayor's office asked Mr. Aleman to get involved in upcoming elections on FMLN's side. When he didn't immediately agree, representatives followed him a few days later, quote, offering him a salary and touting public works that FMLN would implement to benefit the community, end quote. This time, Mr. Aleman flatly refused. FMLN didn't do great in those elections, but they kept the presidency. 5 days after the election, masked gunmen broke into Mr. Aleman's home, put a gun to his head while making him kneel for 40 minutes, and ransacked the home. One of the men asked why he, quote, hadn't accepted the proposal of the party, end quote. They gave him 3 days to leave town. Mr. Aleman didn't report this, knowing that it would go to local authorities, but he fled to his mother's house in a neighboring area. But 2 individuals with guns tracked him down and warned him again, saying they weren't playing games. Mr. Aleman fled to the United States, where an immigration judge and the BIA denied his asylum claim. The Ninth Circuit remanded, focusing on the BIA's no nexus and unable or willing to protect findings. Nexus first. And remember, the nexus standard for withholding of removal is lower than asylum in the Ninth Circuit. Not really important in this case, just good to always remember. As is the fact that the standard of review for nexus remains a bit of an open question in the Ninth Circuit, but I digress. Remember, the 5 protected grounds are race, religion, nationality, political opinion, and particular social group. The Ninth Circuit actually agreed with the agency that Mr. Aleman's religion was not one central reason or even a reason for the harm that he suffered and feared. It doesn't even seem that Mr. Aleman put up much of a fight on that issue before the Ninth Circuit. But the court very much disagreed with the agency's finding that a political opinion claim hadn't been established. To establish past persecution on account of a political opinion, Mr. Aleman needed to satisfy 2 requirements. Quote, first, he must show that he held or that his persecutors believed that he held a political opinion. Second, he must show that his persecutors persecuted him because of his political opinion, end quote. And apparently the Ninth Circuit has reminded, quote, repeatedly, that political opinions encompass more than electoral politics or formal political ideology or action, end quote. Here, the Ninth Circuit believed that the first element in that 2-step standard was easily met. Mr. Aleman had demonstrated an anti-FMLN political opinion, or at least he definitely wasn't pro-FMLN. He told them to their face that he wouldn't help them in part because he didn't believe that they were pro-democracy. And in court, he expanded further how his personal belief was that they were allies of and akin to dictatorships like in Venezuela or Cuba. To the Ninth Circuit, this and other evidence showed that Mr. Aleman held 2 political opinions. First, he believed it was wrong to use his role as a church leader to convince church members to support the FMLN, and second, he thought that the FMLN was, quote, ruining the country, end quote. The Ninth Circuit also believed that the record compelled the conclusion that Mr. Aleman was attacked on account of one or both of these political opinions. Context matters, explains the court, and in the Ninth Circuit it has long been the case that where a non-citizen, quote, refuses to participate in or support a political organization, such refusal may well be a sufficient expression of a political opinion, end quote. Stated differently, and this seems like an important standard to make, quote, a person who rebuffs a political organization need not espouse political theory or deliver a soapbox speech to convey a political opinion, end quote. The question is more, would society attribute political significance to the non-citizen's actions or inactions? If so, explain the Ninth Circuit, you've got prong 2 for a political opinion nexus analysis. And met here, reasoned the court, irrespective of whether FMLN believed Mr. Aleman political or an active opponent. This wasn't about a mere refusal to join a group, explained the court. This appeared more political. That reason alone should probably get a remand, but it's a long decision, and the Ninth Circuit saw a particular social group claim, too. As an initial matter, the BIA simply misstated the particular social group that Mr. Aleman was arguing that he was a member of and that he was persecuted on account of. His group to the Ninth Circuit was, quote, influential church leaders, end quote. Looks like the IJ and the BIA misconstrued that Mr. Aleman was arguing and added circular language, and then rejected that non-made argument as circular, but again, Mr. Aleman never made such an argument, apparently. But that actually led to an even bigger holding, the BIA's position that particular social groups can't be overly circular. in that they're defined in part by the persecution suffered or feared, quote, has no foundation in BIA or circuit precedent, end quote. Take that, Third Circuit decision, which I'm about to do. In fact, to the Ninth Circuit, the contrary, or near contrary, is true even under BIA precedent matter of MEVG. Quote, a group may be deemed impermissibly circular if, after conducting the proper case-by-case analysis, the BIA determines that the group is defined exclusively by the fact that its members have been subjected to harm, end quote. Emphasis by the court. Not the case here, as Mr. Aleman's actually proffered group didn't refer to harm at all. But even if it did, it wouldn't necessarily fail. The Ninth Circuit appears to reason. Finally, the Ninth Circuit believed the record compelled reversal on the unable or unwilling to protect prong required for a past persecution finding or asylum grant. Pretty quick here too, as FMLN was the government at the time, so no real requirement of showing that the government is unable or unwilling to protect, because it was the government doing it. The agency appears to have glossed over this, so it's all going back. But if, of course, on remand the agency believes that it was the Salvadoran government responsible for what happened to Mr. Aleman, he can't be dinged for not reporting the harm under Ninth Circuit precedent. And I mean, that just makes sense, right? As to Convention Against Torture Protection, well, the IJ actually found that Mr. Aleman suffered harm that rises to the level of torture. But the IJ and the BIA still denied, and counsel appears to have done an excellent job distilling and narrowing the reasons for the agency's denial on petition for review, summarizing the agency's reasons as the fact that the FMLN party had lost a local election, and that later, Nayib Bukele became president of El Salvador, and he's not FMLN. Apologies if I've mispronounced the president's name. And so, having narrowed the issues to those two reasons from the agency, the Ninth Circuit deemed them insufficient. The evidence showed, for example, that FMLN still controlled things 5 days after their local loss in that election when the torture occurred, for example. So a remand is happening, but lots more FMLN evidence needs to be considered, explained the Ninth Circuit, even from up to today. Oh, and by the way, for good measure, quote, we have never required that an applicant report his alleged torture to public officials to qualify for relief under CAT, end quote. So I mean, run with that. And remember it for the rest of the episode. Anyway, remanded for many reasons, and while whether the harm suffered was past persecution wasn't actually discussed by the agency, and so is technically an open question on remand, quote, we do note that the agency found that Mr. Aleman's treatment amounted to torture. Torture is inherently and impermissibly severe, and is a fortiori conduct that reaches the level of persecution, end quote. A quote from a footnote, as were so many of the good quotes that I mentioned above. Never skip on the footnotes. And congratulations, Judith L. Wood, Patricia G. Gittleson, and Beth S. Persky for petitioner. Rock on. And that is Aleman Belloso v. Garland. Moving on to Manuel-Soto v. Attorney General of the U.S., published by the Third Circuit on November 12, 2024. This case is about asylum and particular social groups. Miss Manuel-Soto and her children are from Guatemala. The problems for them began when Miss Manuel-Soto broke up with her gang member boyfriend, Axel, and married her now husband, also a petitioner in this case. Axel did some pretty scary stuff and made some pretty scary threats. Axel even almost came to their wedding with a gun. Also, and apparently unrelated, a gang was trying to take advantage of Miss Manuel-Soto and her husband's business, trying to pass bad checks for purchases and then extorting and threatening the family. This is the story of persecution as told by the Third Circuit, and an IJ denied a related asylum claim. The BIA affirmed, as did the Third Circuit, pretty quickly. First, the Third Circuit agreed that the proposed particular social group of, quote, Guatemalan small business owners, victims of extortion by gang members, end quote, is not in fact a particular social group. It's not particular, as its criteria and outer limits are, quote, fuzzy, end quote, and it seems circular to the court, given the inclusion of the risk of or having suffered past harm. But again, recall what the Ninth Circuit just said about an analysis such as that. But anyway, the Third Circuit also deemed that the particular social group was not immutable, as, quote, one can stop owning a small business and so leave this group for good, end quote, two of the BIA's 3 requirements to be a particular social group, so no go. Citing other 3rd and 9th Circuit precedent, the panel did concede, however, that, quote, being a former small business owner might be immutable, end quote. Emphasis by the court. And even in Guatemala, for current business owners, quote, small business owners would still be an immutable trait if, like a religion, it was so fundamental to petitioners' identity that they should not be required to change it, end quote. So, go capitalism. But as a general rule, explained the Third Circuit, and at least without other evidence and testimony in this case, it wasn't shown immutable here, that is, being a small business owner. The court also rejected the petitioner's gender-based claim, in part because the father and the children, who were also petitioners, clearly don't qualify. Moreover, explained the Third Circuit, it appears that the Guatemalan government was willing to protect them, also something required, of course, to win an asylum claim, albeit in the inverse. To the court, quote, they never reported Axel's conduct to the police and never showed that doing so would have been futile or dangerous. Indeed, local police had arrested him for other crimes. And though there is violence against women in Guatemala, the State Department's country conditions report shows that the Guatemalan government takes it seriously, end quote. To the court. Convention Against Torture denied too, in part because the Guatemalan police investigated the business extortion stuff when reported and in any event weren't shown to acquiesce or consent as CAT requires. Again, pretty short one. And the family lost their case. And that is Manuel-Soto, the Attorney General of the U.S. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. We conclude the episode with a trio of decisions from the first. Didn't I just recently sing a song about a trio from the first? This is a trio from the first. Something like that. First from the first is Urias-Orellana v. Garland, published by the First Circuit on November 14th, 2024. And this case is about past persecution and reasonable relocation. Mr. Urias-Orellana's family are from El Salvador and brought asylum claims in immigration court. Mr. Urias-Orellana explained that his 2 half-brothers had been shot and severely injured in El Salvador by a sicario named Wilfredo, who worked for a local drug lord. Seems like it stemmed from a personal dispute. Both half-brothers again are severely and permanently injured, but they also both still live in El Salvador, within driving distance of their old town, it seems. Mr. Urias-Orellana and his family moved towns in fear, but after a few months, they were approached by two masked men who demanded money and then threatened to leave Mr. Urias-Orellana, like his half-brothers, and possibly kill him. Happened again 6 months later. So the family moved again, where they lived without incident for 2.5 years. That is, this third town. But when Mr. Urias-Orellana returned to his hometown to visit his family in December 2020, he was assaulted, extorted, and threatened with death. Then he was followed on the way back to the town he was now living in, so he moved with his family to that second town that they had lived in. He then came to learn that the men were looking for him there, in the second town, and so he fled to the United States. In response to the immigration judge's questions, Mr. Urias-Orellana stated that neither his mother nor his other siblings or nieces and nephews in El Salvador had been harmed or really threatened. Nor does it appear again that the half-brothers have experienced other harms. The IJ denied relief and protection, and the BIA affirmed, as did the First Circuit. First, on past persecution. The court didn't believe the harm bad enough, even assuming that it was indeed the family that was being targeted. Quote, persecution transcends unpleasantness, harassment, and even basic suffering, end quote. And while death threats can qualify, quote, threats must be so menacing as to cause significant actual suffering or harm, end quote, in the First Circuit. Unmet here because, for example, Mr. Urias-Orellana, quote, did not testify about the immediate impact, if any, that these threats had on him, end quote. So, definitely remember to elicit that testimony on direct examination in these types of cases. That is, what the effect of the threats were on the non-citizen, and maybe even what the psychological impact is all these years later. Nor was there evidence that these threats were credible or concrete, rather than simply intended to frighten Mr. Urias-Orellana into paying, reasoned the court. Also, it was only 3 threats over 4 years, highlighted the agency, and the assault to Mr. Urias-Orellana didn't put it over the line for the First Circuit, given the court's similar past persecution precedent, string cited by the court. No discussion on whether the clear persecution of the half-brothers can be part of a persecution claim for Mr. Urias-Orellana, if I'm identifying possible issues. But in any event, without past persecution, Mr. Urias-Orellana must show that he has a well-founded fear of future persecution without the benefit of any presumption, and on that, the First Circuit agreed he could not meet. At a minimum, it was because the record showed to the court that Mr. Urias-Orellana could relocate in El Salvador to avoid the harm he fears. That's a totality of the circumstances analysis per 8 CFR section 208.13b3, which lists several non-exhaustive factors, as does the First Circuit's own case law, including, quote, continued safe residence in the country of removal, end quote, and other close relatives living in the country safely, at least for family-based claims. Those latter 2 things did it in for Mr. Urias-Orellana. He moved twice and avoided harm for long periods of time. And his close relatives lived in-country safely, relatives that Wilfredo would also presumably have wanted to harm. While the record indeed has evidence that supports a finding that relocation isn't and wasn't reasonable, it doesn't compel reversal of the agency, explained the court, meaning that asylum was denied, and withholding of removal had been abandoned. That left only cat protection for Mr. Urias-Orellana, which the First Circuit also affirmed denial of. Although the relevant Department of State country condition report appears to have significant evidence to support Mr. Urias-Orellana's claim, for cat cases, a non-citizen is, quote, obligated to point to specific evidence indicating that he personally faces a risk of torture, end quote. To the panel, Mr. Urias-Orellana failed to do that here at a minimum because of the government acquiescence prong, required for cat protection. For example, Mr. Urias-Orellana never attempted to report any of these threats to police. His reasons for not doing so, to the court, were based on simple speculation that can't win the day for him here. Plus, even failing efforts to control gang violence does not necessarily equate to acquiescence or consent, the heightened standard required for cat protection, explained the First Circuit. Plus, and to end it, even the Department of State's report apparently states that the Salvadoran police's investigative units, quote, have shown great promise, end quote, in managing gangs. So there's that. And it all meant that Mr. Urias-Orellana and his family did not succeed. And that is Urias-Orellana v. Garland. Next is Cortez-Mejia v. Garland, published by the First Circuit on November 15th, 2024. It is strange how often the First Circuit issues its immigration decisions in groups of threes. I don't know what to say. This case is about asylum and El Salvador. The group proffered in immigration court by this asylum-seeking family was, quote, El Salvadorans caught between rival gangs and accused of working with the rival gang based on their work and home locations where the government will not protect them from the persecutor, end quote. I don't know if that was really the group proffered below, but it kind of jumbles a few things all together, as written here in this decision. Mr. Cortez, the father, appears to be the main claimant and testified how he worked at a funeral home in an area controlled by MS-13. Yikes. And his job required him to travel to a workshop in an area controlled by the 18th Street Gang. Double yikes. The 18th Street Gang wanted to recruit him as an informant on MS-13. Terrifying stuff. They threatened to kill him if he didn't. Around the same time, MS-13 came looking for him. In early 2015, 3 men with guns came to his home, showed them their guns, and threatened to murder him if he didn't join the group. He was so scared that he stayed in the funeral home for 2 weeks, and then he fled to the United States with one of his children. His partner, Miss Mejia, also felt threatened. She received a call from an 18th Street Gang member, accusing her of passing information to the MS-13 Street Gang, and threatening to kill her and her son. The caller said she had 22 minutes to leave her home, or she'd be killed with her son. Pretty specific. She fled to the United States. So all 4 family members are now in the U.S., having come in 2 different times. As the First Circuit points out, they were never physically harmed. But asylum seekers need not wait for death threats by the 2 most powerful gangs in Central America to be fulfilled, right? The IJ and the BIA denied. And the First Circuit affirmed. Quote, persecution is a protean term, end quote. Had to look that up to be honest. It means, quote, tending or able to change frequently or easily, end quote. Persecution's got to be more than ordinary harassment and be fairly serious, explained the panel. Other requirements too, of course. And surprisingly to me, the non-citizens did not challenge the BIA's finding that their experience in El Salvador didn't rise to that level, cumulatively, that is, of past persecution. As such, that's the end of the story, and the end of the past persecution issue. So does the family have a well-founded fear of future persecution? Well, first to the First Circuit, it believed that the IJ and the BIA clearly considered Mr. Cortez and his partner's testimony, so the agency didn't err there. Nor must a remand follow simply because the agency did not cite to, quote, relevant evidence, end quote, particularly as here explains the First Circuit, where Mr. Cortez and the family apparently didn't identify the apparent relevant evidence allegedly ignored by the agency below to the First Circuit on petition for review. Plus, the court doesn't see a nexus to a protected ground in this case. Rather, the First Circuit sees simply a generalized fear of gang violence. Terrifying to me, but generalized to the court, and therefore not a basis for asylum or withholding of removal. Convention Against Torture Protection was apparently not sufficiently challenged on petition for review, so the petitioners did not succeed. And that is Cortez-Mejia v. Garland. Our final case, from the First Circuit of course, is Medina-Seguelanda v. Garland, published by the First Circuit on November 14th, 2024. This case is about the unable or unwilling to protect prong for asylum. Quite a bit of that this week, no? But it's also about wonky appellate stuff. So if I may, let's end the show with a bit of a deeper dive into some of these elements for asylum, shall we? Miss Medina is from Ecuador and came to the United States with her daughter and former partner, Fausto. The claim was based on the fact that Miss Medina is indigenous and began her relationship with Fausto when she was only 13 years old and he was 18. Fausto is the father of her child, born when Miss Medina was only 15 years old. And Fausto abused Miss Medina both physically and emotionally in all the ways deemed toxic that you can imagine. Police were even called in Ecuador once, but Miss Medina asked them not to take the father of her child away, that is Fausto. Eventually, Miss Medina was able to escape Fausto and move into another home in Ecuador, but in early 2021, someone broke into that home. Miss Medina believed that the person broke in because the intruder knew that she was a woman living alone who was weak, at the time recovering from surgery. This convinced Miss Medina that she needed to leave Ecuador with her daughter, but she also thought that she needed Fausto's permission to do so, which he only gave under the condition that he joined them. So Mr. Medina, the daughter, and Fausto all came to the United States, and they remained in contact in Massachusetts, where they relocated to. And there is no evidence of abuse during this time. Miss Medina never reported Fausto's abuse to authorities in Ecuador or the United States. Pretty important, it seems, to the First Circuit, quote, when the petitioner was asked by counsel for the Department of Homeland Security who in Ecuador would harm her if she were to return, she answered, nobody, end quote. So that's not great. The IJ and the BIA denied. This despite the IJ holding that, quote, Fausto had persecuted the petitioner on account of her status as an Ecuadorian woman, end quote. Primarily, the IJ and the BIA did not believe the record showed that Ecuadorian authorities were unable or unwilling to protect Miss Medina or people like her. Plus, Fausto wasn't even in Ecuador anymore, he was in the United States. In addition to the claims specific to Miss Medina herself, the IJ and the BIA rejected the claim that there is a, quote, pattern or practice of persecution against Ecuadorian women, end quote. A separate way for people to get asylum, even if they themselves can't show an individualized risk. That is a pattern or practice showing. Anyway, that's a lot of the stuff that the agency held, and the First Circuit affirmed the denial of relief and protection. A lot of the analysis came down to whether in fact the Ecuadorian government or police were indeed unable to protect Miss Medina or people like her, and well, quote, an asylum applicant may establish a government nexus by showing relevant government action or inaction, end quote. Also remember, quote, unwillingness and inability are separate ways for an applicant to establish the required government nexus, end quote. Don't need to show both to win asylum, as sometimes gets mashed together incorrectly in these cases and at the agency level as well. Now here the BIA reviewed the IJ's unable or unwilling to protect finding for clear error, rather than de novo. If the issue is a question of fact, clear error is the correct standard for the BIA to review. But if it's a question of law or a mixed question of law and fact, the BIA should be reviewing this unable or unwilling to protect issue de novo, a much more favorable standard of review for non-citizens where asylum is denied on that basis. By the way, if the BIA is reviewing it de novo because it's a mixed question of law and fact, the First Circuit probably should too. Getting even more nuanced, counsel and amicus argue that yes, the fact findings underlying the unable or unwilling to protect analysis should be reviewed for clear error. But then, kind of like in Wilkinson, right, application of those agreed upon facts to the legal inability or unwillingness to protect standard is a mixed question of law and fact, requiring de novo review. Sounds right to me. And a former Trump attorneys general, if I'm being honest. More of that in a sec. But not to the First Circuit, according to this panel. And to the BIA too, according to this panel, from matter of CGT in 2023. The First Circuit doesn't believe that there exists a defined legal standard for the unable or unwilling to protect prong. Quote, unwillingness and inability are rather ordinary, everyday terms that describe possible factual predicates for the satisfaction of the government nexus element of an applicant's persecution claim, end quote. That means the whole inquiry is not a mixed question of law and fact to the court, meaning that the BIA reviews the IJ's finding on that issue deferentially, as does the First Circuit, and it affirmed the agency. To the court, a quote, asylum applicant who argues that the government was unwilling or unable to protect her usually must demonstrate that she reported the abuse to the authorities, end quote. But where is that requirement in the statute? Queries me. Anyway, though, to the First Circuit panel, this pseudo-requirement can be avoided if the non-citizen, quote, can demonstrate that reporting private abuse to government authorities would have been futile, end quote. That was unmet here. In fact, in the one instance where Ecuadorian police tried to intervene, Miss Medina turned them away. But I mean, man, tough requirement, especially for victims of domestic violence, given the studies about what domestic violence does to people mentally and emotionally. A bit more nuanced here, as it always is, quote, the police's response is a strong indicium that they were willing to protect the petitioner, end quote. Plus, there are criminal penalties in Ecuador for such things, highlighted the IJ, relying on the Department of State reports. Miss Medina countered, intelligently, that, quote, regardless of whether reporting Fausto would have been futile, she should have been excused from reporting him because doing so would have placed her in danger, end quote. Not for nothing, the panel assumed that, quote, danger can, in some circumstances, excuse an applicant from reporting a persecutor to the authorities, end quote. That also cites back to matter of CGT, episode 176. But factually, not present here, reasoned the First Circuit, given the ability of Miss Medina to escape Fausto, for example. As to conditions generally for people like Miss Medina, well, the First Circuit saw a mixed picture, which means that she, Miss Medina, couldn't convince the court to overturn the agency. As to the IJ's belief that it was speculative that Fausto would harm Miss Medina in Ecuador in the future, well, it wasn't so wrong as to warrant reversal. The couple came to the United States together after all, she wasn't harmed in the US, and Fausto apparently remains in the United States. Concluding with whether Ecuadorian women suffer a pattern or practice of persecution in Ecuador generally, the First Circuit didn't see it, for no other reason than, at a minimum, the evidence showing that the Ecuadorian government very well seems able and willing to protect women like Miss Medina. And that means she lost her case. But I have more, from attorneys involved in the decision, no less. So, ACLU New Hampshire came in on this case with some amicus arguments, as they're apt to do in the First Circuit. That means Sang-Yup Kim, and here's what he has to say to me. The ACLU really came in on whether the unable or unwilling to protect thing is a mixed question of law and fact. And Sang-Yup points to, for example, the now vacated matter of AB, which had required, quote, the applicant must show that the government condoned the private actions or at least demonstrated a complete helplessness to protect the victims, end quote. That seemed like a legal standard to counsel. And so if it's a legal standard, might be a mixed question of law and fact. And First Circuit precedent seems to support this too. Indeed, the First Circuit itself has repeatedly held that the Convention Against Torture acquiescence or consent question is a mixed question of law and fact. Counsel, for example, cites the H.H. v. Garland, De Carvalho v. Garland, and Khalil v. Garland, all discussed on the podcast in the past, and all out of the First Circuit. So why would the government nexus prong be different for asylum? Queries counsel. Sang-Yup, however, identifies a potential upside for non-citizens, which so often is the intent of this podcast. Holding might be useful during a Trump 2.0 administration. Pretty safe to say that matter of AB the 4th or something like it is coming back, right? Which might include a requirement, as it did before, that the BIA go over every single finding that an IJ makes with a fine-tooth comb, no matter what DHS is arguing on appeal when a non-citizen wins asylum or withholding of removal. But with this holding here, that is Medina v. Garland, if asylum seekers prevail, and an IJ finds that the government is unable or unwilling to protect them from the harm they suffered or feared, the BIA cannot reverse that under another matter of AB-type precedent without applying clear error review to the unable or unwilling to protect findings made by the IJ. Restated, the BIA can't reverse an asylum grant of the First Circuit by finding de novo that the country's government is able or willing to protect. All good points, of course, and we know that some of this stuff is coming by whoever is eventually confirmed as Attorney General by the Senate. Also, not gonna lie, don't mind it when I don't have to do all of the analysis on these cases. Happy to hear everybody's thoughts via email, if you ever have them, for a case. Just make sure you get them to me before the episode goes live. And that is Medina Sugulanda v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.